pause there. Your regulations are interesting because they suggest that a lot of things are required in a notice to appear except stuff that the government finds inconvenient, like the hearing date, and try to resuscitate the pre-statutory regime that existed before, where the government could issue as many notices as it wanted. So the regulations themselves may or may not comply with the statute, and as Justice Barrett pointed out, they may or may not change. The only statutory hook I think you've identified to save the problem is the clear and convincing evidence requirement. But that's just a clear and convincing evidence requirement that the notice was given. And here the notice would be the Section 2 notice, the notice of change. So none of that means that the NTA, the Section 1 notice, has to be complete, or in fact anything other than a blank document, right?
So, Justice Gorsuch, I think if we were in the world where we have repealed all our regulations and we have somehow, convinced the immigration judge
Forget about your regulations, the law. Your interpretation of the law has to hang together and make sense of the law. Otherwise, it is a trust us argument. Trust us. We will have our own internal operating procedures. I'm asking you about statutory interpretation. And we normally ask, we think statutes are coherent, sensible, not ridiculous. You invoke common sense in your opening argument. And here, one consequence of your argument, I think, is that the NTA can be a blank document and that you can remove someone in absentia based on a notice of change that says show up on a date certain. The immigrant may or may not know that this is really the government. It's just a date to show up in some place. Doesn't have notice of charges or lawyers against him. And the government wins.
So,
right?
Justice Gorsuch, I have several responses to that question. The first is, this is not a case where we are simply asking you to trust us. This is a statute that has been on the books for nearly 30 years.
So let's talk about the statute.
Hundreds of thousands of times.
Am I correct that the clear and convincing evidence rule that you're relying on as a matter of statutory interpretation would allow the government to remove somebody for a blank document, NTA, if they fail to appear on a notice of change? The government can prove by clear and convincing evidence that it issued a compliant notice of change.
Our position is that if a non-citizen receives a paragraph 2 notice, a notice of hearing saying, show up at immigration proceedings at this date and this time, then yes, the non-citizen needs to comply with that. Okay. And if the non-citizen doesn't attend,
and so if that happens,
that's very far away from the facts of these cases.
If that happens, if that's the consequence of your statutory interpretation, we have to ask whether that fits with common sense, you say. Okay. One common sense consequence might be this, that if the government can issue blank notices to appear, which it has found rather inconvenient in the past to comply with that provision, need only file notice of changes and then remove people who fail to show up, why wouldn't it proceed in exactly that fashion going forward as a consequence of a decision in the government's favor in this case, when, as I understand it, and my figures may not be exact, about a third of cases in immigration proceedings are in absentia removals, so failures to appear. So why not issue a blank NTA, because they're hard, they're pain, we found them difficult, then issue a compliant notice of change, show up on a date certain, and then remove about a third of the aliens in this country without any notice of the charges against them or their right to counsel or anything else, and then deal with the remainders and file compliant notices to appear in those cases.
So, Justice Gorsuch, we do not do that and have never done that.
I'm not
for
asking
several
you.
Reasons.
Let's put aside the trust us arguments. What would prevent the government from following where the incentives of that decision might lead as a matter of law?
And Justice Gorsuch, what I'm disputing is that we would have any incentive ever to do that, because if we did that, if we used the blank document, there would not be a removal proceeding under our own regulations in which to order the non-citizen removed. So we have no incentive to do